Your Honour, my name is Sebastian and I am appearing on behalf of the prosecution. I will be making 4 submissions to you today, the first of which is that Adam is neither competent nor compellable to provide evidence against the accused. Under subsection 9 of the Evidence Act, there is a presumption of competence for all witnesses. This is further expanded upon by the decision in Hoskin and Metropolitan Police, which provides that this implies compellability. However, there is also the relevant section here of section 8, subsection 2, as the accused is the spouse of the proposed witness. This provides that they are prima facie both competent and compellable. However, we must then consider section 8, subsection 1, as they are both co-accused. This section provides that they are competent but not compellable to provide evidence for the defense. In addition to this, the decision in Callanan provides that the spousal rule takes precedent over the co-accused rule and that they would, up until this point, be competent and compellable. However, we are not appearing on behalf of the defense, and so section 8, subsection 1 is irrelevant. Rather, the important case here is the Queen and Payne, which provides that the co-accused are not competent nor compellable to provide evidence for the prosecution. Further, subsection 10 prevents them from being compelled to provide any self-incriminating evidence. We therefore conclude, Your Honour, that Adam is neither competent nor compellable to provide evidence for the accused. And so, we request that the matters of the co-accused be heard at separate trials in order to allow for the co-accused to provide evidence compellable and competent against each other. On the alternative, Your Honour, we request a nolla prosequi for Adam's case. That concludes my first submission. For my second, that Michael is competent and compellable to provide evidence for the accused, I bring you back again to section 9 of the Evidence Act. This provides the presumption of compellability to all for all witnesses. Please note also that this section explicitly states that it is not an issue if the witness is a child. Further, the decision in R and Brazier provided that even an infant's age is not necessarily an issue in their ability to act as a witness. I therefore conclude that there is no issue against Michael's compellability and competence as a witness. Further, Your Honour, as a child witness, we request that under section 9E, he be provided the ability to provide his evidence via video link. For my third submission, that Jennifer is a competent and compellable witness for the accused. I bring you again to section 9 and its reasoning, and my reasoning which I have discussed before as to why Jennifer's age is not an issue regarding her competence and compellability. I also submit to you that there is no issue under section 9A subsection 2 as regarding any lack of capacity to provide an intelligible account of the situation. However, Your Honour, if you were to raise any issue under this section, we're prepared to provide expert evidence to the effect that Jennifer did have the capacity to provide an intelligible account of the situation. Therefore, Your Honour, I provide that Jennifer is both competent and compellable. We further request under section 131A that Jennifer be provided an interpreter to allow her to submit this evidence in an understandable manner. Now, Your Honour, for my fourth submission, that despite the lack of relevant warrant, the trial judge should not exercise any discretion in excluding the CCTV evidence. It is clear here that the basis of the decision in Bunny and Cross is not relevant in our case. In the case of Bunny and Cross, there were 5 indicia which were provided in order to determine when the public policy discretion should be used. I will go through these 5 now to explain to you why it is not relevant in this case. The first indicia is that there is a deliberate disregard for the law or a mistake. This is relevant on the facts, and so the next indicia of the cogency of the footage is irrelevant. However, the main point in this instance is the third indicia provided by Bunning and Cross. This was that there was a genuine response to a pressing need. It is clear here that in our case, the public policy discretion should not be used on the basis of this indicia primarily. That the footage would have been destroyed by the accused, or most likely would have been, had the actions which this police officer taken not be taken. Further, the fourth indicia in the case is whether it was a grave defense, which is additionally equally convincing on these facts given the charges against the accused. Such a genuine response to a pressing issue for such a grave accusation clearly avoids any justification for the use of this discretion.